All right, everybody, it is 8 a.m. It is Thursday morning. I'm excited to be talking about NABOR financing today. I hope you're all having a good morning so far. Thank you for joining me. Today, we're talking about Naples Area Board of Realtors contract financing provision. So my name is Sam Saad. I am an attorney in Southwest Florida, and we are going to talk NABOR financing. So because I am an attorney, we'll start off with a disclaimer that I'm providing you advice, but you cannot rely on it for any purpose other than what we talk about here today. And if you have any specific questions, please feel free to reach out to me. We'll set up an attorney-client relationship and we will help you out. Just a little bit about me. I am a 20 plus year attorney. Been practicing in Southwest Florida for over 18 years, and I'm a member of the Florida Bar Joint Drafting Committee, so I know the FARBAR contract. I'm a member of the Naples Area Board of Realtors Legal Resources Committee, so I'm very familiar with the NABOR contract and the current scribe of that committee, so I actually help write that contract. And I'm happy to answer any questions that you have as we go through the NABOR financing provisions today. I have a title company that I conduct real estate transactions through, real estate closing services. We are, I think, the best option for your business. So if you need closing services, please give me a call. My cell phone number is on the screen, and I'm happy to talk to you about your closing needs. As we dig into the Naples Area Board of Realtors contract, specifically the financing provision, I have a few initial thoughts. First of all, you have to have a good relationship with your lender. Super important now. There's some bad case law. The Florida Investment Group 100 LLC versus LaFont case, not a good case, hurt real estate transactions in Florida. And we'll talk in a moment about that case. But remember that if you use the NABOR contract versus the FARBAR contract, they have virtually opposite approaches in the way that they approach financing in a real estate transaction. So we'll talk about the NABOR contract today and do a little comparison with the FARBAR. Just also remember, by the way, never skip blanks in these contracts. Fill out the contract completely, kind of a professional practice tip for you. Do not skip blanks in the contract. Before I dig into the contract, let's talk about this LaFont case. It is not a good case. It is the buyer lost their deposit because she did not apply for the loan that was stated in the contract, and the court really strains itself to give the deposit to the seller. And the real issue here that you need to take away from this is if you have financing in your contract and you need to change the kind of financing, whether it's from FHA to conventional or VA or whatever the type of loan is, or the loan amount, or the interest rate is going to be different than what's in the contract, you really need to, I should say, higher than what's in the contract, and the buyer wants to move forward, you really need to amend the contract, particularly if the loan product changes. So let's talk about the NABOR contract. Let's look at here on page 1 of the NABOR contract. Because of the LaFont case and because of the wording of the financing contingency, it is very, I'll say very 50 times important that you put the proceeds of any mortgage that's going to be gotten in the contract. Excuse me. Very important that you put the amount borrowed right here on line 36 of the contract. And this applies to the regular contract, to the as-is contract, the vacant land contract. Do not skip the proceeds of any mortgage that's going to be provided to the buyer. Now, when you are in the NABOR contract, for those of you that saw the video on FARBAR, it was a very simple cash purchase option in the contract, just that the buyer will pay cash. NABOR takes a different approach, and it says that you may pay cash, that you will pay cash, but you may obtain a loan. However, there is no financing contingency, and NABOR clarifies that you must close on the closing date. You do not get any grace period on a cash transaction. So that will become important. It's more important in the FARBAR contract, but just be aware of that in the NABOR contract. So this is the financing contingency in the NABOR contract. It's one paragraph, and you can see here, I'm going to go through it, and then we're going to talk about some bullet points and break it down. But subject to the provisions of this paragraph, buyer's obligation to purchase the property is contingent upon buyer obtaining a loan, unless waived by buyer as set forth below, in the amount shown in 1B above. Remember, that's line 36 that we just talked about, to be secured by a mortgage on the property. And then you pick your type of loan, and you pick whether it's going to be an initial or a fixed rate of interest, and you put the interest rate amount here. And notice there is no default, so do not skip this blank. Please do not skip this blank right here on line 64. There is no default, and you do not want to subject your buyer to any interest rate that they might get, particularly in this high interest rate environment. You very well could be committing realtor malpractice. So again, do not skip the percentage blank in the NABOR contract because there is no default. Then you pick the term of years for the mortgage. Typically, it's a 30-year mortgage. Could be a 15-year mortgage. Could be something else depending on the financing. And then you need to determine how many days you have to make application to the loan in this blank right here. And Jessica, you're asking me if we can put the prevailing rate in the percentage blank. I would not do that. You subject your buyer to whatever the rates are, and maybe they don't want to pay a high rate of interest, or maybe they can't afford a high rate of interest. And so it's just an easy way to clarify that the buyer is willing to go up to X percentage as an interest rate. I would not put prevailing rate. Okay, so going through the provision a little further, the buyer shall make a continuing good faith and diligent effort to obtain the loan and comply with all applicable requirements of the creditor lender and the CFPB rule relating to the loan process. So the lender is going to have to make a good faith effort. That's going to mean things like pay for the appraisal, pay the lender fees, get the paperwork to the lender so that they can adequately underwrite the loan, your W-2s, your tax returns, any corporate information that they ask for. Super, super important that you get that information to the lender in a timely fashion so you're not in breach of contract. And then going further along in the paragraph, if the buyer fails to waive the contingency on or before this date right here, and you can either leave it blank and it's 45 days, which I think is very long. I would go down to 21 or 30 days for loan approval. Put a date there or leave it for 45 days after the effective date. Again, I think that's very long. If you do not waive the financing contingency in the NABOR contract within the approval period, then either the seller or the buyer may terminate this contract at any time. What does that say? Either the seller or buyer can terminate it after the loan approval period is over at any time. So you run into this situation where the seller's remedy, and remember in the NABOR contract, the seller's only remedy is deposits if there's a breach. You run into the situation where, in this case, the seller's only remedy, if the buyer does not waive the finance contingency after the period is over, the seller can just terminate and give the deposit back to the buyer. This remedy is very important to think about for your sellers because your seller may think, well, they didn't get the financing. It's been a long time. My property's been off the market. I get the deposit. Well, no, it's the opposite of the FARBAR. The seller gives the deposit back to the buyer, and the seller goes on to find a new, more qualified buyer. So be very, very careful about how you handle um, your sellers in the NABOR contract. Now, the buyer, when they go to terminate, if they don't get the financing in time, the buyer's right to terminate must be accompanied by one of two things: either a statement of adverse credit issued by the lender, or, see this or right here, other evidence from the lender that the buyer made a loan application and made a diligent effort to get the loan, but has not gotten the loan yet. So what does that mean? The buyer at the end of the loan approval period can terminate the contract and get their deposit back if they've made a good faith and diligent effort to get the loan but have not received the loan, or if they've been denied for the loan, then they can terminate and get their deposit back. So what happens if the buyer waives the finance contingency and is prepared to close on the transaction? Well, then we go to closing. And if the buyer waives the contingency and is unable to close on the closing date due to a delay caused solely, this word solely is very important, by the lender or the CFPB rule, then buyer can extend for 10 days. So let's break this down. Buyer waived the finance contingency. They're ready to go to closing. They've got their clear to close. They waive the finance contingency, and they aren't ready to close on the closing date because of the lender is getting the document package organized. Maybe it's a mail away. Maybe there's the CFPB rule compliance period for signing of the closing disclosure. If the buyer has properly waived the contingency, then the seller cannot terminate, and the buyer gets up to 10 more days to close the transaction. And notice here this last sentence. Buyer acknowledges that once buyer waives this contingency, buyer's deposits are no longer refundable under this paragraph 4. So once that contingency is waived, the deposit is hard, but just because you got a loan commitment, it does not mean it's a waiver. You've got to affirmatively waive the contingency in writing using the forms provided by NABOR. So let's break down these bullet points a little bit more. Buyer's obligation is contingent upon buyer getting financing according to the terms of the contingency. It's very important to fill out the contingency. You need to know your loan product. That means you're talking to your lender earlier. You have to pick VA, FHA, conventional, or other, and you need to know the interest rate, whether it's fixed or variable. We talked about that. The default time for the buyer to make application is 5 days. Now remember, in the NABOR contract, time is not of the essence for anything but the closing date. So if the buyer fails to make application, then on the 6th day, the seller needs to put the buyer in breach of contract and say, get your application in or I'm terminating and I'm going after the deposit for your failure to make a continuing and good faith effort to obtain the loan. And we said the default period is 45 days. If the buyer does not waive the contingency, the seller or buyer may terminate after the contingency expires. So remember, in the FARBAR contract, the buyer's got to terminate during the finance contingency period, or they're going to lose their deposit when the period ends. In the NABOR contract, you cannot terminate until the period ends, and then the deposit goes back to the buyer if either party terminates. And this is the biggest mistake agents make. They get panicky. The loan approval period is coming to an end. They think they've got to waive or they've got to get approval or they got to do something, and they don't. What you can do in the NABOR contract is the buyer can continue to make loan application, apply and work through the loan approval process with the lender once the contingency is over. And if the seller is okay with that, they can keep the deal together. You can either extend the contingency if the buyer wants to, or you can just let it ride and get your approval and go to closing. It's not essential that you either party waive the contingency or terminate. And then, of course, the seller cannot terminate if the buyer waives the financing contingency first. And we talked about
a question.
Oh,
I'm sorry to
go
interrupt.
ahead, Jessica.
I was in a situation where I had a closing scheduled, and it was a Friday, and we had the clear to close, but the package didn't arrive to the title company in Marco Island until a certain period of, I was like afternoon, and that title company closed early. So because of that situation, the title company wasn't able to, provide closing that day, and they were going to move it to Monday. But the listing agent wanted to terminate the contract, and they wanted their deposits to go to the seller. They were very upset.
So
And
go ahead.
in that situation, I asked my broker at the time, what could I do? This was actually for my personal house. I was freaking out because my deposit was at risk, my house, my move. I was like, oh my God. And it was out of my hands. The package just happened to get there too late. And this title company that the seller chose was in Marco, and they closed early. Anyways, they broker read that slide that you had right before this one, or the one where in NABOR contract it states something like, after the waiver contingency expires, the buyer has
The bold
10.
language here on the screen.
No, it was like 2 slides before this one, and I'm confused because this one right here where it says, if buyer waives this contingency. So I don't believe I waived the contingency. No,
If
where'd
you
it go?
didn't waive the contingency, so that's a great point. If you
And
did not waive the contingency and the closing date passed, then the time is of the essence for closing. So the contract just terminates and you get your deposit back.
I can't see, that's where now I'm going to go back to my file and check. I don't remember waiving the contingency, but my broker spoke to their broker and they said I had an extra 10 days.
If you did not waive the contingency, then you did not have 10 days. The contract terminated. I hope you closed the transaction.
Oh, I did. This was a couple years ago. It's the house I
Okay.
live in. But because of that 10 days period, it saved my deal. Broker
Yes,
to
that's
broker.
the purpose of the 10 days. Yes.
But I did not waive my contingent. I don't remember. So in the future, if I'm ever in that position again with a buyer, I would have to make sure that the buyer signs a waiver in order to be able to apply those extra 10 days
That's
if something
correct.
were to happen. Because if
That's
they
correct.
don't have a waiver signed and we don't close by the closing day, then we don't get 10 days extra.
You don't get 10 days extra, but you get your deposit back because you didn't wait. There's an unfulfilled contingency at closing.
Okay, well, then I'm safe either or.
You were safe. If you didn't waive, you were safe. If you use a title company like Paradise Coast Title and Escrow, we'll be open and get you closed on the closing date.
Absolutely.
But yeah, that's crazy. They closed early. That's funny. But
Yeah, on a Friday.
the finance contingency in the NABOR contract, if you do not waive it and you go to the closing date and the closing date passes, time is of the essence for closing. So the contract terminates at midnight the next day and after the closing date, and you get your deposit back. Now the seller's not going to like that. The title company is going to be is going to be scared to release the deposit, and there's probably going to be a lawsuit involved if you don't close. But you should get your deposit back. Okay, Guy is asking, hold on, Guy is asking in the chat, is it a good practice to match close date and contingency period? Guy, I don't know if that's a really good practice. The one thing I'll say about that is if because you waive the finance contingency, you don't want to do that until you get the clear to close. It's not just good enough to get loan approval from the lender because they've got to underwrite the property still. You know, if it's a condo, they got to get the condo questionnaire. If it's a single family, they got to check all the, you know, the HOA and everything. So it's that may be a good practice. It just is going to frustrate your seller that you have a contingency that goes all the way to closing. So that's a point that's going to be negotiated every time. Someone else had a question.
Yeah, Sam, and Jessica,
Yes,
it's Marcia. In Jessica's example, she talked about the fact that the seller chose the title company. So would you just remind me, please? I go back and forth, guys, from a couple of states, so please forgive this question. I know it won't apply to anybody but me. But in Collier, the seller chooses the title company, correct?
No, it's by tradition and by custom. It's not by law or rule, so it's 100% negotiable. But typically in Collier, the buyer picks the closing agent.
The buyer does. Okay, all right. So
And
in my
remember,
case
in
with
the
this
NABOR contract, the escrow agent listed on the contract on the last page at the bottom is the person that holds the money. The title agent, the closing agent, is picked by the buyer in every case.
And so title companies don't.
NABOR contract.
Okay, so title companies don't mind, like Palm Coast. You wouldn't mind that that we have a seller and we're using you as the escrow agent. That's something that you agree to as well.
We do that. We handle both sides no matter what. Whether we're writing title or not.
Okay, thank you. Sorry for the question. That, as I said, I know it doesn't apply.
I'm sorry to interrupt again, but I have because of Marcia's question, I was actually just talking about this yesterday. So in the NABOR contract, it was my understanding yesterday that it's already in the contract that the buyer chooses title, but if it's a Collier property, buyer pays. And if it's a Lee County on a NABOR contract, seller pays?
That's exactly right.
Is that correct?
Yep. Buyer always picks in the NABOR contract, but in Lee County and Charlotte County, the seller pays for the title policy. And in Collier County, the buyer pays the title policy.
And then in FARBAR, you choose whether the buyer pays or the seller, but there's actually check boxes that you choose.
That's correct.
Okay. Thanks.
And Michael is asking, what's the practical advantage of one side or other picking the title company? Michael, it's control of the closing. It becomes a big deal in a contentious deal where everybody's fighting and you need skilled closers that can understand the contract like we do and lawyers involved who can fight for the party that they're representing. It's control of the closing process. So like, for example, if you've got a squirrely seller, and the buyer's trying to get a loan and you're using the seller's title company, now the buyer's paying a fee to the seller's closing agent for the loan closing process. There is a financial advantage to control some of the closing costs. You're asking if there's a financial advantage. You control the closing costs and you control the process. That's really the two reasons to pick the title company. Other questions about the NABOR financing contingency? It's not very difficult. You simply put your information in, apply diligently and with good faith to get the loan, and you work through the contingency period to get the loan. You waive the contingency once you have your clear to close, not just your approval, but your clear to close. And if you don't have a clear to close and you're the buyer, you don't waive the contingency because you'll lose your deposit.
Sam, I have a question.
Yes, ma'am.
Can you confirm again what you said? If somebody it's a Lee County listing and the buyer is working with an agent NABOR. Excuse me, they're working with a NABOR agent and they want to use the NABOR contract in Lee County. where the seller usually pays. How does it work, did you say?
The
What
buyer would
was,
pick the title company and the seller would pay for the owner's policy. And that's not a big deal because the owner's policy amount is set by state statute. So the seller is going to pay for that owner's policy, and it's going to cost the exact same regardless of who picked the title company, what the title company name is, who the lawyer is. It's set by state statute. It's the same no matter what. So it shouldn't matter to the seller that the buyer picks the title company. That's just the NABOR default, that the buyer always picks the closing agent.
I have a fun one for you.
Sure, Penny.
So I have the buyer and we're looking at assuming a VA loan. Okay. I didn't see anything in there regarding any VA assumptions in NABOR.
So you would have a financing contingency, but you would have to choose you'd have to write into the contract that the buyer may assume the seller's loan, and you probably would need some special language in there that says if buyer is unable to assume the loan for any reason, then buyer can terminate and get their deposit back. They don't contemplate assumption in the NABOR contract, so you would need to write something in.
Okay. And plus on top of it, it's a foreclosure and probate. So
That sounds like a fun one.
yeah. I mean, but the interest rate is 2.75. I'm like, let's go for it. You know?
Well, in my office, we handle probates and we handle difficult closings with great regularity. So just let me know if I can help you in any way.
Okay. And with that being said, because I guess I wasn't familiar that for Naples, we get to pick the title, but I just thought because there's so many wheels in this thing, just staying with what the seller has for the foreclosure title company. I don't know, is that
you have to do what's best for your customer.
okay?
If your customer needs help from an attorney and the seller is adamant about handling the title because it's a foreclosure and it sounds like a probate and whatever else is going on, then your buyer can hire me and I will be their attorney and I will work with the seller's attorney to get through the foreclosure and the probate issues. And my job would be to make sure the buyer gets that marketable title. Remember that marketable title is what they bargain for in the contracts, and that's very important.
Okay.
And then Michael was asking, can you write these things in or do you need an attorney? Michael, I would always use or have your language blessed by an attorney so you don't get in trouble for the unlicensed practice of law, which is a felony. So write down what you need to write to cover your buyer or your seller in the additional terms, but get an attorney to bless it. You can shoot me an email. I'll review it, give you some feedback, and I do it almost immediately. So you can always just shoot me the email and let me help you. Other questions?
Sam, what about if it's seller financing? Does an attorney have to write that up, like
Absolutely,
the terms and all?
you need an attorney for seller financing because you have to draft a note and mortgage. Yes.
Okay.
Title companies really should not be handling seller financing. Other questions you all have? I put a few final thoughts on the screen. It's very different in NABOR world from FARBAR world. This is a more buyer-friendly contract, but the buyer has to keep trying to get the loan during the contingency period. So if you get denied, go apply again or talk to your seller and say, listen, I'm not going to get this loan. Do you want to put your property back on the market? Don't just stop trying if the loan contingency period is still going, because then the seller might say you didn't exercise diligence and good faith. Okay, with that, I'll take questions on this or anything else that you have related to the contracts or anything related to your business. Just give me unmute yourself or put it in the chat. Any questions at all?
Hey, Sam, it's Guy.
Hey, Guy.
I want to go back to my question from earlier.
Sure.
So again, if you match the term of the contingency period and the loan closing, from on the positive side of my mind, the buyer won't be exposed by having to waive their contingency, so they're protected by the contingency to
Right.
closing. What's the disadvantage of doing that?
Well, for the buyer, there's none because you have a contingency all the way to closing, and if you don't waive it, the contract just terminates and you get your deposit back. For the
Right.
seller, now he's got a property off the market for 45 days or whatever it is, and he doesn't have a closing, so he's out of luck. So again, just got to look. It's kind of what's that phrase? Where you stand depends on where you sit.
Yeah.
So it's kind of, for the seller, you want the shortest contingency possible because your only option as the seller is to kick the buyer out and get a new buyer, and you don't get any money out of it if you don't have a closing. So if you're talking from the buyer perspective, then yes, you may want the contingency to run almost all the way to the closing date. But if you're the seller, you want the shortest finance contingency possible so you know you have a deal.
Yes. Yeah, I mean, when I've written contracts with the contingency period matching the closing, most times there's no issue. But to your point, every once in a while, an astute realtor on the other side or seller will make it an issue, and then we'll have to negotiate that.
Yeah. And if I've got the seller, I'm always shortening the finance contingency period in the NABOR contract. Always.
Yeah.
I'm pushing it down to 20 days, 21 days. And because you can always negotiate extension. If the buyer is doing a good job, there's good communication, the realtors are getting along, the title company's got the commitment, and you're moving to closing, then the seller can always say, I'll give you 5 more days. It looks like you're almost there. You're just getting or if the lender has approved the borrower, but they're working on through the condo issues, for example, trying to get the condo questionnaire signed by the management company. The management company's dragging their feet. The seller may say, I'll give you a few more days on the contingency, or the seller may say, I'm not going to terminate right now, even though I'll have that right when the contingency period ends because we're getting close.
Yeah,
So,
but if the seller perceives or believes that they can get a better offer
yes,
or
the
more
seller gets
qualified
the
buyer, they
opportunity to
can
better
kick you to the
deal.
curb.
Yes.
Yeah.
Yep. Brenda, you can get all the recordings out of my YouTube channel. That's an excellent question. Saad III at YouTube. Other questions? All right, everybody. Thank you so much. We're going to have another one in a couple of days. I'll talk to you all soon. Thank you so much for logging in this morning, and have a wonderful Thursday.
Thanks, Sam.
You too, Sam. Thanks.